All right. I believe that we're ready to go. Welcome to the 2023 Kansas 10th Circuit Historical Society presentation. We do these every year. This year is our first attempt to do a hybrid presentation. We've got a room full of folks, and we have online, I believe, is being streamed right now by Zoom. We had about 800 registrants, so they are pouring in right now. Hopefully, we're good to go. If there's any technical glitches, let us know. We've got Q&A and we've got comments. In the Q&A, if you are not live, if you have questions for the presenters, please put your questions in the Q&A. We're going to have those questions will be addressed to the extent we have time at the end of the presentation. If you are in person and have a question, please do it the old-fashioned piece of paper way and walk it up to us, or just bring up the question. There will only be a handful of questions that we'll probably be able to get to, but we will get to them. We're approved for CLE in all 6 states in the 10th Circuit, plus Missouri for our dual licensed attorneys. If you have questions about CLE, please email cle@josephhollander.com. We'll be able to answer those questions, or you can try to put it in the Q&A question or the question section online if you're by Zoom. Finally, affidavits are available for in-person, and instructions for registration or for CLE credit are provided in emails. Presentation is by the 10th Circuit Historical Society. The goal of the society is to preserve and promote knowledge of the history of the development of the law in the 10th Circuit. This is one of our efforts to do that with the annual presentations. There's also newsletters, and we try to preserve the history as best we can. Membership is encouraged for those who are attending. It is actually quite inexpensive. There's QR codes on your materials. You can sign up. I think it's only $25 for attorneys, $10 for students, and judges actually have to pay more at $50. So relatively inexpensive. We would ask that you consider. Today, the presentation is about Federalism on Trial, States Attorney Generals and the National Policymaking in Contemporary America. We have 3 presenters, the first of which is Professor Paul Nolette, who wrote a book with that exact title. Professor Nolette is an associate professor of political science at Marquette University. He is currently the director of the university's Les Aspin Center for Government based in Washington, D.C. His focus of his research is on the role of states attorneys general. And again, he wrote the book, ironically published by the University of Kansas Press. Steve Six was our 43rd Attorney General for the state of Kansas. He is currently a partner at Stevie Siegel Hansen in Kansas City, where his practice focuses on antitrust, class action, and complex commercial litigation. Also with us is Derek Schmidt, who is our 44th Attorney General for the state of Kansas. He is the state's 2nd longest serving Attorney General and has recently joined private practice at Hush Blackwell. And with that introduction, I will turn it over to Professor Nolette.
Thank you very much. And thank all of you for being here today, either here in the courtroom or watching online as well. I'm very excited today to have this conversation with our 2 distinguished guests here as former AGs here in the great state of Kansas. And, you know, I'd start just by saying that the role of the state AG goes back to the very foundations of the country. As new states entered the union, typically they would start a new AG position either in their constitution or by statute. And so there's a lot of history here with state AGs. And for me, somebody who's studied AGs for over 15 years now, part of the reason why I'm still on the AG beat after all these years is that it's such a fascinating position. It's really unique in many ways in American law and policy. So one of the things that I just wanted to start the conversation with today, and either one of you can kind of pick this up first, is just to get a sense from you, how would you describe the role that you held? I mean, what do you see as being distinctive or unique about this position in state government?
Well, I'll take the first swing at that. Professor, thank you. And thanks to everybody for joining today, and appreciate the Historical Society putting this on. The Office of State Attorney General really is unique. I think you could make an argument, it might be a bit overblown to suggest it's unique in the world, but it is certainly unique in both American law and American governance. The notion that out of the 56 state and territory attorneys general, I think it's 45-ish, I'm off a little bit there, are elected public officials as opposed to having, getting office through appointment or some other matter, makes them by definition political players. And they have to operate within the boundaries that the political system allows in their particular jurisdiction at any given time. Otherwise, they don't do the job. They don't get to do the job. And yet, unlike every other elected political player, the nature of the job is they are lawyers. They're officers of the court. They have legal duties and responsibilities. They have to operate within the limitations of the law. I often think of it in my simple way as sort of the classic Venn diagram with that overlapping area in the middle, which is smaller in area than for most public offices, where the realities of politics and the requirements of the law overlap. That is a state attorney general.
Mm-hmm. Yeah, I mean, I agree with that, Derek. I mean, it's a unique position personally for a lawyer. You have opportunities to do amazing things, argue before the United States Supreme Court, which Derek and I both did, try lawsuits in small parts of the state and represent the state as really the head of the largest law firm in the state. You have these diverse clients who need counsel, and the issues that come up are super interesting. So I very much enjoy my private practice, but rarely do interesting issues like I saw in the AG's office come up. And then the folks you work with, I think both of us experienced some of the brightest, youngest lawyers. The pay may be lower than other law firms in the state, but people looking for experience and to do things, get trained there and move on and do other big things across the state. So
yeah, and I definitely want to get to some of these questions about the blend of law and politics in there as well, but also picking up on something that Steve mentioned. You mentioned the opportunity to represent the state, and one thing I want to get your thoughts on is the question of who is the AG's client. Who is the AG's client? Because on the one hand, maybe the obvious answer is, well, it's the state. But you often hear about AGs as being the people's lawyer or representing the public interest. So I'm curious to get your thoughts on that.
Well, I think we've got states now where I think 19 of them have supermajority Republican legislatures and 9 of them Democratic. And in those states, probably the AG and the governor agree on who the client is. In some of the other states, you do see this interesting issue where there may be a policy issue that the AG or the case law may view as the way to go, and a political player, perhaps the governor or somebody else in the state, may have a different view. And you have seen in the past where the governor may file a lawsuit and the attorney general of that state may take a different position. So my view was it was the state of Kansas. I was never presented with something where I thought the public policy differed from what I thought and lawyers in the office thought was the right way to go.
Mm-hmm.
Yeah, I think that's true. You have to look at the particular matter to figure out who the client is. I mean, in some cases, it's easy, right? If the office is defending an individual state employee in some type of personal injury or wrongful termination or something like that, then it's clear who the client is. It's the individual. Well, at least in most cases it would be. But on higher grade matters that are more policy based, where the actual named party is the state on whichever side of the V, where there are judgment calls to be made by the client, and the state is the named client. Is it the governor? Is it the legislature? Is it a subset of the legislature? Is it the attorney general, especially in a state where the AG is elected, which is a position I often defaulted to when it was difficult to decide. I served with always with Republican majorities, sometimes super majorities in both houses of our legislature during the years I was there, but I served with both Democrat and Republican governors. And, back to my Venn diagram, there were times it was easier to sort of square the circle and stay within the overlapping lines than at other times. My experience, which varies from state to state, is it was usually easier to resolve the differences without the whole world seeing them when you had players of the same political party. It didn't mean there weren't differences, there were plenty, but you could usually get them resolved more quietly, which I think was healthy for the state. It's never really good when two senior officials are quarreling in public, in addition to trying to do their jobs.
Mhm. Yeah, and one of the reasons why the Office of State AG is so interesting, particularly these days, is that you have all these duties at the state level. Sometimes there are conflicts, sometimes there's cooperation, but also state AGs play such a big role on the national stage these days as well. And I'm curious if you might say a little bit about that, and maybe to start us off too, really talk about the role of tobacco and the master settlement agreement, because for me that was a really kind of a key moment for state AGs and showing how they can really make a difference on the national stage. And so even though the MSA that was settled back in 1998, before both of you were in office, but of course you very much had a lot to do with tobacco and AG's will for many years to come. So I don't know if you wanted to say a little bit about the MSA and kind of the emergence of AGs on the national stage.
Go ahead.
I'll start that one. I agree with the analysis. I mean, I do think the MSA was a watershed in terms of the role of state AGs, unrelated to the subject matter of tobacco or whatever it may be. And remember, when the MSA was entered into by whatever it was, 46 states or however many finally entered the actual settlement, it was at least the second bite at the apple. A lot of folks who haven't focused on it forget that there was a first bite where the same or substantially the same group of states thought they had reached a multi-state settlement with the relevant tobacco companies. But because there was a desire by the group of states, and this is why it's a watershed in my mind, at least, there was a desire by the group of states not just to resolve the dispute in the particular litigation, but to regulate the industry, to change the behavior of the entire industry, whether they were parties in the litigation or not. The Joe Camel issue, if you remember, right? They wanted to stop using this litigation. States wanted to stop certain types of product advertising. That's sort of remarkable. If you think about it, it doesn't seem quite as remarkable today as it did at the time. And the first bite at the apple, the attempt to do that in terms of the first preliminary settlement, acknowledged the traditional way of doing that, which is Congress regulates. And I recall at the time, I wasn't involved in the issue directly, but I was a Hill staffer in Washington at the time. My wife was a little bit involved in it. And I just remember when that group of AGs, bipartisan group, came to the U.S. Senate and said, hey, we've reached this deal with these tobacco companies, and now would you guys please pass this law for us? That didn't go well. It wasn't well received, sort of in the spirit of who are these people and why do they think they can come tell us how we ought to legislate federally, which is why then the second bite at the apple, there were these more creative ways of trying to regulate the industry. So but ultimately the AGs prevailed in what they set out to do. And I think that's why it sort of changed the culture among AGs and the expectations and raised the bar.
Mm-hmm.
Yeah, I mean, I agree with Derek on those thoughts. I mean, I have sort of two thoughts about it. I mean, the first was I was a young lawyer at a firm that was trying to be selected by Kansas to represent the state, and we weren't. So I regret that that didn't go our way. But more importantly, I think, federalism ebbs and flows a little bit based on power and absence of power. And in my personal view, too long, there was an absence of power in Congress on regulating an important issue, the public health related to smoking, for the types of reasons we still have today, that it was a powerful industry, and Congress is not good at regulating powerful industries. And in that absence of action, the AG stepped up and in my view, did a remarkable thing to achieve probably the biggest step forward in public health and the biggest social welfare benefit to the state that you could probably point to. And now when they do a similar thing on an issue like opioids, it's not as revolutionary a thought. So not being a smoker and having spent a little time in a country this summer where they smoked, I'm quite proud that they achieved that result.
Yeah, and that's in many ways, I think, a good segue, saying it's not as revolutionary, to think about AGs and playing this role as well. And I promise I don't have too many PowerPoints for you, but I do have one slide that I wanted to show you here that comes from data that I've collected about AGs. And this shows you the number of multi-state settlements that concluded by year. And as you can see, you know, a lot of this activity, so AGs getting together, working across state lines, often on bipartisan basis, on multi-state settlements, pretty uncommon in the 1980s. It started becoming a little bit more common in the 90s, but then after tobacco, it's become far more common. And Steve mentioned, you know, opioids being one of the most pressing issues today, and AGs really are taking the lead on these issues. And so I'm curious to pick up on that point too, about Congress. I mean, is this a story of Congress not doing its job, you know, or Congress leaving these big gaps open that state AGs go into? Is there more going on here? Should we all blame Congress, in other words?
Well, you might have to put a pin on where you think Congress stopped being effective. And if it's around the time Newt Gingrich started his revolution from my political side of the aisle, that may line up fairly well with your chart on when AGs became more involved. But I do think that is a big part of it. Probably, I haven't studied it like you, but there were Bob Dole and Tip O'Neill coming together to solve something. And in the absence of Congress solving it now, either, which we'll probably get to, the administration solves it with an executive order and AGs have a reaction to that, or state AGs banding together, step in and want to do something about it.
Yeah, and I should just mention too, as far as a lot of these multi-state settlements that have emerged over time, some of those early ones, they were a lot of the AGs involved in the 80s and 90s. It was a lot of food labeling stuff. And they were essentially saying, hey, the feds aren't doing their job. The FTC is not, you know, bringing cases, this sort of thing. And so we're stepping up. I mean, more recently, since tobacco, it's been a whole bunch of different issues, as you're well aware of. I mean, opioids for sure, financial regulation, mortgage crisis, you know, the list really goes on and on with consumer issues, antitrust, all of this sort of thing. So yeah, I don't know if you wanted to kind of say anything about sort of the role of Congress and how the AGs might react to that on a federalism basis.
Yeah, I'm not sure I'm going to say anything substantively different, but I would frame it a little differently. I don't think I would say it's not, to use Paul's words, it's not Congress not doing its job. It's Congress not filling its space. And those are different points, right? It can be a judgment call to not fill a space, to leave it unfilled. Some might view that as doing their job, depending on your philosophical point of view on a particular issue. But in the absence of federal action that fills the space on a particular subject matter, you know, it invites other players to move in. And since the MSA, I think state AGs have felt increasingly willing to move in. And I imagine we're going to get there, so I'll just frame it and then leave it on the table. But you know, we've talked so far about moving in to those spaces when, you know, the target is the regulation of an industry, a private industry, and that's certainly very real. You know, there's sort of a second basket related to that, and I think Steve foreshadowed it with the regulatory piece, which is moving in when, you know, it's federal action or inaction itself that states decide to join together and challenge. And we sort of saw a second wave of that really starting about the end, I think, of the first decade in the 21st century. And that's just stepped up dramatically since then. A lot of folks used to say, I sued the federal administration a lot. I got done. I feel like a you know, junior varsity player. I think the next 4 years, some of my counterparts filed like 4 times as many suits against federal agencies and federal actors. And I think those numbers are likely to remain sustained unless Congress becomes more aggressive in filling some of those vacuums.
Yeah. So in fact, another great segue here, I think, because to talk about another aspect of the AG's role. So, you know, you have these multi-state settlements. A lot of times those are bipartisan. You have AGs working together across state lines against, you know, corporate actors and so forth. But another huge part that's already come up a lot is AGs either individually or working together to push back against the federal government. And this happens on both sides of the aisle, particularly, of course, when there's a president of the opposite party in office. And just to give you a sense of that, I have another slide here from my data. This is rather kind of amazing here. So this is the total number of multi-state lawsuits by AGs against the federal government, and I have it broken down by term. So this is, consistent in terms of the number of years, 4 years going by. And as you can see, there was a little bit of a uptick starting around the George W. Bush years. So in the 2000s, second term of Obama, quite a few lawsuits as well. And then with Trump, it was just like, the ceiling just, was blown apart there. A record number of multi-state lawsuits against Donald Trump, even though it's come down a little bit. I mean, there's already been more lawsuits against Biden than there was in either of Obama's terms or any other presidents that preceded Trump as well. So, I mean, this activity is really ramping up big time here. And I think what's also important here, one other thing that I just point out about the data is that a lot of those earlier cases were kind of like traditional, well, maybe I'll call it traditional federalism conflicts, in the sense that a lot of them were environmental conflicts, like upwind states versus downwind states arguing over air pollution and things like that. But now the range of issues is just enormous. Every hot button issue you can imagine: healthcare, immigration, the environment, civil rights, all of these sorts of things, AGs are involved. So I guess maybe I'll start by kind of asking, what do you think's really kind of triggered this? And why are AGs using their offices, particularly on a multi-state and partisan basis, to really push back on the federal government far more than they have in previous years?
Well, it's a great question, Paul, and I think really two things to think about. I mean, one, why, and two, is it a bad thing or a good thing? Starting with the why, I think it touches on a little bit of what we've talked about. I mean, take an issue, immigration. Congress hasn't done anything on it. The states and other entities need something done, and so attorney generals step in when the administration then takes an immigration action, and executive order will go out, and some states may view that as a solution and some states may view it as an overreach, and that brings the issue to the court and it percolates up, and we have a good system for dealing with disputes. So very learned judges out here in the audience can determine, is there standing? Sometimes that's a good filter to make sure we're not having too many lawsuits. If the judges decided here, it goes up, and we all know the appellate system and eventually the Supreme Court. So I'm not a glass half empty, pessimistic view of your chart. To me, I think we've got a great court system. It handles these things. It creates a process. If it goes through our process and you lose and you're sitting there whining about it, I don't have a lot of sympathy for you. I mean, it's not perfect, but it's pretty good. So I'm not worried about that. I suspect it'll eventually, if we put it out and forecast it into the future, Congress will become more effective and these numbers may go down.
And you also see this. So this is multi-state lawsuits. So this is over typically pushing back on regulations or policies that Congress has enacted. Sometimes, though, brought to say Congress hasn't acted or an agency hasn't acted and they need to act. Those sorts of cases are in there too. I will just mention that the kind of increased polarization that we've seen around AGs shows up in other areas as well. And this will be my last slide for today, but just another example from the data. This shows the percentage of Supreme Court, so U.S. Supreme Court briefs that were filed by AGs of all of one party, which is also interesting. So you can see, AGs have filed amicus briefs in the Supreme Court for many, many decades. Generally speaking, a lot of them were bipartisan. A lot of them had to deal with criminal justice issues and other federalism issues that AGs agreed on across party lines. But in more recent years, it's been a different story. as we've seen AGs get involved in a number of different national issues and on a partisan basis. And I guess one thing that I just wanted to ask, I'm really curious about your thoughts on this is, I mean, how do these two things interact? I guess how does like this sort of thing, where you have more partisanship and polarization amongst AGs, does that sit uneasily with the bipartisan nature of the job, like tackling opioids and thinking about big tech and these sorts of issues? I mean, is there a danger there that this might have a kind of an effect on the other side of the AG's duties?
Well, I'll step up on that. There are certainly a lot of folks that lament that, what they view as a change. I will say, and this is not by way of criticism, it's by way of observation, the majority, in my experience, of folks that lament the change are folks who were here before participating and are not participating now. And so, there's perhaps an element of the good old days analysis that goes into that. I actually think it is possible to, a phrase I've often used, both walk and chew gum at the same time. You can, as a state attorney general, you can engage in what comes to be more partisan litigation and engage in more traditional nonpartisan litigation. And one doesn't exclude and doesn't have to taint the other. It's not to say it doesn't, we're all human, but it doesn't have to. I served as president of our nonpartisan National Association in the midst of the ramps up on your graph, and I chose to focus for all of us that year on elder abuse issues. Why? Because I thought it was an issue that brought all of us together, and it was an area we could sort of safely find areas of cooperation, both in terms of public policy advocacy and in terms of enforcement, in terms of resource decisions, and we could sort of maintain the collegiality on that at the same time. We might have been slugging it out on other issues that were a little more partisan. And the last thing I'd say, I don't view it as necessarily inherently a bad thing. The numbers that you show on your graph, checks and balances are integral to our system. And if one traditional check and balance isn't functioning in the manner it historically has, for whatever reason, having another step into the void is not all bad. And I don't think it's surprising that on some of that type of litigation against the federal government, you see, much more party purity in terms of who joins and who doesn't join. Because back to the Venn diagram concept, you do have to survive the political reality, and it's not necessarily courageous to step up and join a brief on the other side. It's not bad. It's just not inherently courageous. What's courageous is figure out what you think the right position is and figure out how you can get to be an advocate on that. So,
Yeah. And Paul, I mean, maybe to add a couple of thoughts to that. I mean, I think you see cases where AGs are on the same side. There's always outliers, but broadly on the same side. And I guess my observation is those are often very situations of really strong malfeasance, opioids, 2008 mortgage crisis, or their law enforcement issues, drugs, whatever. Then you get cases where AGs are on opposite sides. You have 20 AGs with an R and 15 with a D, and they're on opposite sides of an issue, bringing a lawsuit. And then I think the issue becomes who's the referee, and who's the referee, and can you choose the referee? And under our system, you mostly can't. You can choose where to file. And sometimes, as AG Paxton has shown in Texas, you can pick a district where you can choose the referee, or you can choose your circuit. And you think about some cases that rise top of mind on any particular social issue. We've had some recently. The Republican side filed in Texas in the Fifth Circuit, and the Democratic AGs filed in Washington State and the Ninth Circuit. And, that's why they chose to go where they go. It doesn't guarantee any outcome, but it's those kind of things. So I think that raises interesting questions about, what's the relief they're seeking? Is it nationwide injunction relief? How does that play out when you have different circuits and appellate courts dealing with those kind of things?
Yeah, and that's a really, really interesting kind of dynamic that's been happening here, because of course, we have AGs across the country. And even if they are working together on a lot of issues, at least on a partisan basis, you can often have different groups against each other and individual AGs suing and that sort of thing. I mean, do you think that that's sustainable, particularly when increasingly AGs are going to different circuits, as Steve mentioned, or certain districts, and then asking for national relief? So then you have a national injunction by one group of AGs that directly conflicts with another group of AGs seeking a very different national injunction. I mean, this sort of thing, national injunctions were not common, certainly 5-10 years ago, but have become a lot more common. And AGs are asking for them almost as a matter of course, not as just extraordinary relief anymore. So I'm curious to kind of get your thoughts on that as well, and whether, is this another area where Congress should step in and say, well, we want to make sure, or the courts and step in and say, we really want to have, make sure that there's one rule that applies everywhere across the country?
Well, there are folks, no doubt, who are intellectually pure on the question of the merits or demerits of a national injunction. Can one district court block an entire statute or regulation nationwide? Setting aside those who are intellectually pure, as a practitioner for a state, it usually depends on whose ox is being gored, right? I mean, you want the nationwide injunction if you're on the side that wants the injunction, or if you're in a state that's not a party in the particular litigation that obtained the injunction, but you want the relief. That's another dynamic that, back to the political side of state attorneys general, this phenomenon we're talking about here, it presents some really challenging issues for case management for AGs. I mean, I'm thinking of a particular matter. It doesn't matter what it was, but we had made a strategic decision among a group of states that were going to challenge a federal action to divide into groups, even though we were all like-minded, because we wanted to get as rapid a decision as we could. And we figured one of three things was going to happen. Either we filed in, let's say it was 4 different circuits, all of them were going to rule our way, in which case we won. All of them were going to rule against us, in which case things didn't look good, or we were going to get a circuit split, in which case the prospects for a more rapid final resolution were improved. And so strategically, we did that. If that happens, and let's say you're on the side that wants an injunction, and you happen to be in the group of states where you don't get the injunction from your lower courts, but some of your sister litigants do get an injunction in their courts, it is really awkward to explain to people back home why, there's an injunction in North Dakota blocking this problem from our perspective, but not in Kansas. So you can be a big fan really fast of nationwide injunctions if you're on that side of the question, and obviously reverse as well.
Mm-hmm.
Before you go on too far, for our 600 attendees that are online, we need to launch a poll. So we're going to go ahead and launch that real quick so that everybody can respond.
Right. Yeah. And, I imagine kind of the same sort of thing. It depends on, whose ox is being gored and that sort of thing when it comes to some of the other procedural things. I wanted to get back to the forum shopping or the judge shopping issue, because this actually came up last month. The House of Delegates of the American Bar Association, they met for their annual meeting and last month voted to have an official statement kind of pushing back on this judge shopping. So essentially litigants going to particular courts and trying to pick their judge or pick kind of a small number of judges. And of course, the ABA was careful not to say that this was associated with any cases, but the Texas AG, Louisiana, more recently have employed this strategy, certainly on the Democratic side. As mentioned before, so many of their cases are in the Southern District of New York or Northern District of California. So it's like, well, so I don't know, what is this something that really is a major problem and should be dealt with? Or should we say, hey, AGs represent their whole state. They should be able to sue wherever they want within their state? Well,
as a AG from Kansas, I always preferred suing just in state court in Kansas on issues if we could. Whether it's a problem, I think certainly the hot button issues that come up that a particular maybe group of AGs could get a nationwide injunction on, there's a well-resourced opposite side of AGs who will seek out another court or somewhere where they think the law and the precedent supports maybe their position, and get that moving forward at the same time. And then, you know, we've seen the Supreme Court jump in and issue stays on particular rulings. So to me, the system's set up to deal with it if it becomes a crisis. You know, Justice Alito issued a stay the other day on an important issue, and they're effective at doing that. So I don't see the sky falling on it. I agree it's an issue. I mean, to me, there's a difference between researching the law and finding a circuit and case law that supports particular issues you want to advance, and, you know, trying to get a particular judge, whatever, you know, if that's possible somewhere for the reasons you've talked about, Paul.
So, you know, thinking about the future too, and where the Office of AG is going and what some of the opportunities are there, as well. I'd be curious to get your take on, you know, what would be helpful for AGs moving forward? I mean, thinking about the offices themselves, I'll just give one example. One thing that has become far more common in AG offices all across the country is the position of Solicitor General. So really kind of mirroring the U.S. Department of Justice, and that setup, having somebody who specializes on appellate work, and that's really spread like wildfire around AG offices, including, you know, here in Kansas. And so I'm curious, are there, you know, when you're thinking about the structure of the office and how things work and all this complexity that goes into the multi-state stuff, plus the single state stuff and elder care, and then more polarized issues and all this kind of stuff. I mean, how do you think about, you know, the structure of the office and how to move forward on a lot of these issues to make sure that the AG can handle everything that they're expected to handle these days, which is a ton of stuff?
Well, I think with at least one former Kansas Solicitor General in the audience with Steve McAllister here, we'll say it's a good thing. And certainly with Judge Krause, a newish judge on this court who was a former Kansas Solicitor General, you know, I found it to be terrifically helpful to have that level of expertise. I mean, having, for example, Steve McAllister, who's with us, who has a specialty in Supreme Court practice, often at a mid-level state AG practice like Kansas, where you're not as big as California or maybe Texas, you don't always have somebody in-house with that degree of Supreme Court issue spotting. And I think, Derek, I don't know how many cases you took up, but I'm sure that was helpful.
Yeah, absolutely. It was very helpful to have the skills to sort of have the, you know, the teacher on staff for the guy who cycles through the office as the elected official. We took up 8 from Kansas on my watch, and we had 8 good outcomes. So it's a good thing we quit while we were ahead. But you know, that was a surprising number, including, you know, now Judge Krause and I did 3 in a 28-day period in the fall of 2019, which we continue to claim is the most any state has ever done in rapid fire, and we're going to claim that until somebody else shoots us down. We haven't found anybody who's done state that's done 3 in 28 days. You know, on the issue of the Solicitor General's office, I think it is, you know, I think it's almost essential at this point for an effective state AG's office. It's certainly helpful. And I think it's helpful for the courts. I wouldn't presume to speak for the courts, but you know, I know through our national association, we typically once a year have a chance to meet with at least one of the justices. And I recall one meeting we had with Justice Kagan, who sort of sua sponte, we weren't talking about this, but she raised it and praised states as a general group for moving toward having solicitors general, because she thinks it's improved the quality of state advocacy overall. And that's in turn helpful to both the court and the development of the law. So I think it's a positive thing. You know, talking about generally evolving, you know, state AG offices. I mean, back in the 50s, I think the Kansas AG office had, you know, Steve, I think it was like 8 attorneys or something like that. That was it. And at least when I left in January of this year, I think we were at 70 some, I forget the exact number, maybe a little more than that authorized. We were like everybody having hiring challenges, but I don't think that trend is likely to reverse. don't think that trend is likely to reverse.
Mhm. Yeah, and the one other way that over time, at least, that AGs have helped to manage some of the complexity is by working together in shared forums. So the National Association of AGs, as Derek mentioned before, you're president of the organization about 5 years ago. Do you see NAG playing a similar or the same role in kind of helping to coordinate AGs across the country moving forward? Or do you see more of that kind of shifting to the, like the Republican AG Association and the Democratic AG Association? Is NAG still going to be playing a big role in helping to coordinate bipartisan activities by the AGs?
I don't know Steve's perspective on it. My point of view, I think the answer to that latter question is yes, it is going to continue to play a role. They've got some bumps at NAG right now, which are reflective of broader dynamics in the AG community, but they're going to get through that, and they're going to continue to play that role, because if they don't, somebody else is going to have to. There are still plenty of things that AGs need to do together, either on the soft side, sharing of information, or the hard side, working together on litigation or sort of post-litigation wars like MSA compliance, that has to be done. And it doesn't have a partisan veneer. And if you didn't have, as I said to somebody recently, if you didn't have NAG, you'd have to invent a NAG, because you have to have somebody to do that. That doesn't take away from the reality that at the same time, as we've talked about, there are other, some would say more novel, certainly newer types of litigation that NAG's not going to touch, nor should they, because they'd have a revolt in their membership, because half their members would be furious. And so, the partisan organizations have grown up, and I think over time they're going to likely continue to play a bigger role in filling that sort of NAG-like role, but in the more partisan-based litigation. I think the associations reflect where the membership is, not the other way around.
Yeah, I mean, we're in a post-cooperative federalism, I think, position, and politics, whether it's state AG's office or elsewhere, is unlike any we've seen before. I think certain legal and procedural norms have been crossed, and once they're crossed, the next AG who's seeking to do something and go somewhere pushes it further. And so I guess if I'm not pessimistic at all about how the court system handles things, I'm a little pessimistic about some of the lawsuits that AGs have brought recently that I think intrude into areas that are dangerous to the republic. So that's maybe a line I draw. And most of those came post 2020 election.
So what do you see as really coming up, I guess, for AGs? Both, and you can kind of go from either angle here, thinking about the two parts of the AG's job, the more partisan part. Obviously, we have an election coming up in 2024. But then also in terms of some of the regulatory stuff as well. I mean, we have a lot of new technologies emerging, AI and these sorts of things. What do you see as being some of the big challenges you think AGs will be getting involved in the kind of near and medium term?
Go ahead, Derek.
Well, yeah, thanks. Yeah. Certainly just to pick up on, Paul mentioned AI, certainly in the technology space, where the technology is growing far faster than the development of the law. And as a consequence, there's sort of a vacuum to deal with what I'll call regulatory consequences. Others might term it differently, but, with the consequences of that, that's an invitation for states through their attorneys general to step in. And I think if you look at some of those tech-based cases, they've so far largely been bipartisan cases, even though, they might on their face appear to be a little more of a partisan nature. But, the litigation against Google, for example, that's in the news this week is, I think, if I'm not mistaken, I think Texas and maybe Tennessee on the Republican-led side have helped lead that. And then you have a group of Democrat-led states. So, I'm very encouraged about that, to the extent that we want to measure the ability to cooperate in the Venn diagram across party lines. I think change probably invites more cooperation where everybody's a bit uncertain.
Yeah, I mean, I guess I'd say buckle up. I mean, we've got an election coming up. We've got states who have moved to remove one of the candidates from the office based on constitutional arguments that may appear before judges in this circuit. We've got super majority legislatures seeking to remove state Supreme Court justices before they start their position for power. And, you know, it's as old as Roger Penn Warren and all the king's men. Politics is power. It's not principle. It's principle when you're not in power. Once you get in power, the principles limit your power. And so you move away from them to just power. And I think the court system, in seeing these issues in the next 2 years, is going to be tested. It held before, and I think it's going to be tested, but will hold again. So I think we got a lot coming.
I think we do. Well, we wanted to give an opportunity to open it up for some questions here, both those of you who are here present in the courtroom, as well as those who are following online. So let's take some of those questions if you have some.
Well, I'll speak to that. I mean, Steve, I'm not picking a fight with Steve. I just used the phrase a while ago, threat to the republic. And I think we're at a point in our history, maybe we're often are here. You know, this is the only moment I've ever lived in, so I can't speak to that. But I think we are at a moment in our history now where a lot of Americans genuinely believe threats to our republic, but they certainly don't agree on what the threat is. And that's an important point. And those differences among our population tend to get played out in legislative fights, in elections, and in the courts. And I don't think that's a particularly novel concept. And so we're going to see, more and more of that, I think. So I don't think it's an end run. I mean, when we say setting policy, maybe that's a phrase we've used, and if so, it might have been a bit inartful. You know, some people see the overarching threat to the republic as, just to be colloquial and blunt, to make the point, federal bureaucrats setting policy that nobody elected and accountable ever authorized them to do. And for a court to be asked to say, you can't do that, that's not an affront to the separation of powers. That's enforcing the separation of powers. So, depends on which shoe the foot's on, I suppose, how you view it, which foot the shoe's on, how you view it.
Yeah, I think the only observation I'd make is, I think when you get a court system that we've talked about that resolves it with the process we have, and you lose and you don't accept that, to me, that's where we've moved. And certainly during my time as a lawyer, 30 years, this is the time I've seen that happen. I haven't seen that happen earlier in my years. So the Supreme Court tells the legislature, redraw a district to affect these voting laws, and the legislature doesn't do it. Or a candidate loses an election and they don't accept, that. So I feel it's a little bit different, but we'll see.
And just, to add to that, for balance, I don't disagree with that general point. Back to my point of, it depends on where you sit, or an administration is told by the court, you can't take this action with respect to student loan relief, and they come up with another way to try to do the same thing, or mortgage relief. So it cuts both ways in terms of the, the politics, and courts sort those things out.
So do you think, I guess this is the broader question though, of again, going into what's surely going to be a very contentious presidential election, national elections. Is there's been a lot of concern, and certainly I share a concern. Concerns have been put up here about polarization and where this is going. I mean, is there a way to turn that around at all? I mean, and can the AGs maybe play a role here? And I kind of go back to the point about, that Derek made, saying, when he was NAG president, he really focused on issues like elder care. This matters to lots and lots of people, but it tends to kind of get shoved under the rug a little bit in the media because people aren't talking about elder care. They're talking about, the big polarized issues of the day. And so I wonder if, it just strikes me that the office of AG is one that can really emphasize those bipartisan, accomplishments and all that work that assistant AGs are doing and the staff is doing in these offices on a day-to-day basis. It gets much less attention perhaps than some of the polarized stuff. And so I wonder, maybe this is kind of, I'm hopeful, I'm optimistic as well, but perhaps, state AGs can play a role here in shaping the narrative a little bit about, polarization that's so deepened in our society today.
Well, I mean, I think state AGs do a lot of important things on protecting consumers in their state and elder care and whatnot. On the issues we've highlighted, the political issues, if I was going to look for a group to try to bring the parties together, I don't think I'd start with the state AGs from what I've seen. So, yeah, I mean, there's a role, I think, in some of these issues where there's common agreement, but I think there's going to continue to be division on the hot button issues that catch the news.
Mm-hmm. Any other questions out there?
If there's a question in the audience.
Well, I was just going to ask, how do you submit your budgets and ask for funding of, I want to spend this much of my staff's time on basic governmental functions and the traditional representation of agencies in the state versus I want to spend a lot of time filing multi-state class actions or challenging government agencies? How do you budget that?
Well, I can't, I'd actually be interested in how Steve handled that on his watch. I can tell you what we did on my watch, and, I can't speak to what came before, nor can I speak to, what's come after, because I'm not there. I made a decision early on, we were going to be more active in that space, and we were, but we weren't going to sort of grow the office to accommodate that space, and we didn't. We fit it into our existing structure and our existing budgets. It's one of the reasons that on a lot of these multi-state cases that were challenging, for example, federal actions, very few of those did we file with, Kansas doing the principal carrying of the load. There were multiple reasons we did it that way, but one of them was, if I could have Texas, or if I could have Oklahoma, or for a while Michigan, or like I say, Florida, carry the cost of litigation and still have a role at the table in deciding litigation strategy and how things unfolded, and still get the benefit of the outcome, assuming it was what we wanted. Back to the issue of, are you part of a non-nationwide injunction group of litigating states or not? Then why did I need to add additional capacity dedicated to that? So to your question, I never asked for dedicated money for that. And although I took a lot of political shots over all 12 years, probably longer than that actually, for look at all the money he's spending on this, litigation on challenging other states or federal actions. The reality is, if you added it up, it was very little, especially because, we don't pay lawyers by the hour at the state AG's office. It's a fixed cost, and you can make an opportunity cost argument or a diverted resources argument. But unless you go down that road, we didn't spend much at all. And that wasn't accidental. I made that decision. Others make different decisions.
And I don't know if you want to comment on any of this, but I know a number of AGs, and there has been controversy with this, but have used outside counsel and kind of tapped outside counsel in both the multi-state corporate context, as well as to assist with some of the pushback against the federal government. Any thoughts on that? I mean, I think states are still struggling about and state AG offices are still struggling about what the right balance is there, of using, people outside the AG's office, bringing them in as either special AGs or kind of helping with some of the complex litigation over pharmaceuticals and things like that.
I mean, I found it a useful tool when I was AG. I mean, we hired Fulton Siefken to handle some litigation for us, and we hired some out-of-state firms to hire their litigation. I think the process is important to, do it through a transparent RFP process, so you can make sure that the process in hiring counsel is legitimate, and then making sure the AG is involved and keeping track of it. I don't have a problem with it for the reasons Derek just outlined. Some states don't have as many assistant AAGs, and many of them are busy in cases with the prisons and other clients. And so to take on a new piece of litigation and bringing in outside expertise, I think could be very useful.
Mm-hmm.
Yeah, I agree with what Steve just said. The only thing I would add is, analytically, at least in my mind, and I've not seen a lot of this in the literature, maybe I just haven't seen it. I do think there's at least potentially an analytical difference in how to address your question. How do you use outside counsel and that kind of, whether the state is in a plaintiff or a defense role. On our watch, we used outside counsel a fair amount in a defense role, and I felt like we didn't have a choice, either for expertise reasons, the state gets sued, or some state represented defendant gets sued on a matter we just didn't have the expertise on in-house. We had to go out in the marketplace and get it. I'm thinking of a securities matter right now that we handled on our watch, or just a capacity issue. Litigation is going to be tremendously complex. We have a lot of firepower on the other side, and we just don't have the litigation management systems available in-house, which doesn't reach the question of the quality of the staff. We had great people. We just weren't resourced for dealing with, being buried in motions practice and discovery. And, I thought we owed it to our clients to go get the resources, and that was how we could do it. That's perhaps a different analysis from what I'll characterize as a more discretionary use, which is state as a plaintiff, at least in many cases. I did that too from time to time, but less often. So it seems to me there's sort of an analytical difference potentially.
Mm-hmm. I think we may have time for one more question. If you have any burning questions, either here in the courtroom or online.
We've received a lot of questions about when you're setting public policy, who the client is. How do you decide that? And I think Derek mentioned a couple times there's some infighting, but I mean, people were asking, how's that really look like? What's it really look like? Who are you representing? If you're making policy through litigation, who decides? What's the state of Kansas? You ever go against your party, even was asked.
Sure. I mean, we already talked a little bit about that, but I'll just give you my kind of rule of thumb that I always use when I first looked at a matter, and then often things got much more nuanced, much more rapidly. So, but if the state itself, the state or the state of Kansas was the party, my starting point was I'm the Attorney General elected by the people of the state of Kansas and empowered by both the statutory and common law of the state of Kansas to represent the state of Kansas. And that means I've got a lot more decision-making discretion than if the governor was named as the party, or the Secretary of State was named as the party, or a cabinet secretary was named as the party. Now, that's the starting point. That's not the ending point. And unsurprisingly, when the state is named, it is quite frequently litigation that's much more fraught with, dynamics that may go outside the four corners of the litigation. And I didn't have a death wish. I mean, I certainly wanted to bring in the people that needed to be at the table on the state side. And I think we always brought them in. We may not have always gotten things resolved, but I think we always brought them in and tried to. And
Yeah,
sometimes, I remember a conversation one time with a former legislator who was an attorney and a practicing attorney who was just furious with me over a position we'd taken in litigation, and it was politically fraught litigation. And I finally said, I'm a lawyer with a client. I mean, I'm not going to tell you how we got here, but I'm a lawyer with a client. And that was just such a novel concept to this person, which was surprising to me. This was not an unsophisticated individual. They just assumed you're the Attorney General. This is the position you've taken, and it was your judgment call. That's not always the case, but it is sometimes.
Yeah, and I mean, on this client issue too, one follow-up on that is when you think about these big multi-state cases, I mean, is there sort of an analysis sometimes to say, hey, this train is being driven by, someone, whether it's New York, California, or whatever, maybe one of the big states, and it would actually make more sense to say, no, Kansas should go its own way. I mean, and what sort of considerations go in there when you say, you know what, we're all, AGs who agree on the problem, but the solutions we're starting to disagree on here, and we really shouldn't be part of the multi-state effort.
Yeah, I mean, there's one group of those type of cases, Paul, that are like against businesses. The pharmaceutical industry has provided a seriatim series of cases that the AGs have got involved in multi-state fashion because the drug either didn't do what it was supposed to do, injured the state in various ways, or Medicaid or something. And, in that group, those things don't really come up. It's sort of the suit's brought, the group comes, the money's paid, the state takes the money. The smaller group is, I think, when you come up on a more political issue, which I think you're identifying. And, the opportunity there, of course, is always to either stay in or get out. Primarily during the shorter time I was AG, we were dealing with groups on those issues that were amicus briefs, not lawsuits. So much easier to see the final brief and decide if it aligned with what Kansas wanted to do. The lawsuit's a little trickier. I mean, you file the lawsuit, you're part of the group, and one of those AGs stands up and says something, it can tend to, I didn't file any of those lawsuits, so I don't have this personal experience. I just observe it. It looks like it can create issues.
Okay.
Yeah, I think we've hit the 60-minute mark. Everybody has earned their CLE credit. And I want to thank the three of you for coming, especially Professor Nolette from flying in from DC, but of course, both former attorney generals for sharing their insight of their time in office and their views and this very interesting topic. So thank you for attending, and for everybody who is in the audience and online. Thank you for coming as well. And again, please consider going to the website and considering joining the 10th Circuit Historical Society. Thank you much.
Thanks.